We will call to order the council meeting for Wednesday, April 4th. If everyone would stand for the prayer given by Reverend Melvin Williams and the pledge by Fire Chief Chuck Montero.
Let us pray. Our Father and our God, the giver of every good and perfect gift, the author and the finisher of our faith, the God in whom we move, live, and have our being. This again, Father, we come calling on your most holy and righteous name. We call because we need you and can't get along without you. You've been good and you've been kind, for you have brought us from a mighty long ways. And our Lord God, most mighty and most holy and merciful Savior, thou know the purpose for which we have come, that thou would lead us and guide us and help us to say and do those things that pleasing in thy sight. Bless everyone who's here tonight. We be careful to give you the glory and honor. But we ask it all in Jesus' name. Amen.
Amen.
Please turn and face the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
If everyone could remain standing for just a minute, we are honored tonight to have a special guest, Miss Caitlin Cayette, who's a sophomore at Dallasville High School. She's also a 2011 Idol finalist and a 2012 Ascension semifinalist, and is a Louisiana State finalist this year in the National American Miss Pageant. Miss American Pageant, excuse me. Thank you, Caitlin.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we've watched were so gallantly streaming, and the rockets' red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave.
Thank you, Caitlin. That was beautiful. Roll call. Ms. Secretary, we have all members present with the exception, nope, Councilman Turner's here. We have all members present. There will be no chair's additions. Item number 4 is the public comment sign-in period. Reminder, if you wish to speak, now is the time to come sign up and you will have your 3 minutes. Please come fill out a comment card if you wish to do so. Okay, the public comment period is now closed. We will move on to item number 5, which is our presentations for the month. President Tommy Martinez.
First of all, I'd like to call Stephanie Breeden up. Of course, it's that time of year, and this is our 5th consecutive year that we proclaim Child Abuse Month in Ascension Parish, and I think for every one of those years, Stephanie's been here, and this year, looks like congratulations in order that we're going to have a new little child here in Ascension Parish and a new citizen, and we want to congratulate you first of all on that. And I'll urge all of you to please wear a blue ribbon this month. It's a symbol, and as I said, Stephanie does a great job, Casa does a great job for the parish. I'd like to read this proclamation. To proclaim April 2012 as Child Abuse Prevention Month in Ascension Parish, Whereas child abuse and neglect are complex and ongoing problems in our society, affecting many children in our community. And whereas every child is entitled to be loved, cared for, nurtured, feel secure, and be free from verbal, sexual, emotional, and physical abuse and neglect. And whereas it is the responsibility of every adult who comes in contact with a child to protect that child's inalienable right to a safe and nurturing childhood. And whereas Ascension Parish has dedicated individuals and organizations who work daily to counter the problem of child maltreatment and to help parents obtain the assistance they need. Whereas our communities are stronger when all citizens become aware of child maltreatment prevention and become involved in supporting parents to raise their children in a safe and nurturing environment. And whereas effective child abuse prevention programs succeed because of partnerships among families, social service agencies, schools, religious and civic organizations, law enforcement agencies, and the business community. And whereas all citizens, community agencies, faith organizations, and businesses will work to increase their efforts to support families. Now, therefore, it be proclaimed, I, Tommy Martin, as President of the Parish of Ascension, State of Louisiana, by virtue of the authority vested in me, do hereunto proclaim April 2012 as Child Abuse Prevention Month in Ascension Parish. Stephanie, would you like to say a few words?
Every year when I come here, I always say a few words about who we are and what it is that we do. And I don't think that I ever share any stories about the work that our CASA volunteers do and the work that we do in the parish. Just to give you an example, we serve kids who have been abused and neglected and been removed from the home. A lot of those kids don't have anyone to speak for them. They go to court and the judges have to make decisions for them, but sometimes they need a little help in making those decisions. They need an unbiased, objective person to come into court and talk about what's going on with that child. Someone who is committed to making sure that that child has all of their needs met, has counseling, is in school, has somebody who cares about them. So many of these kids don't have anybody. A lot of times when they're removed from the home, sometimes their parents are able to get it together and do what they need to do and get their kids back, but a lot of times they're not. We recently had a kid who had absolutely no one. She came into care, had 18 different placements, which is a lot for a teenager. 18 different placements. She had no one to care for her. Her parents didn't want her anymore, didn't care about her. She had a lot of serious abuse that happened to her in her lifetime, and no one wanted to care for her or even cared about her because of the behavior she displayed, because of the abuse she went through. But she had a CASA volunteer who stood by her every step of the way, who stood by her when she went to school, who stood by her to make sure that she got the proper education, stood by her to make sure she got housing. And now she's about to turn 18, has a job, has a GED, is ready to live life on her own, has a place to live, because her CASA worked so hard to make sure that she had someone in her life, and she had someone telling her every day, you can do this, you can do this, you can do this, and you can have a better future. And I just thank you so much for your support in the work that we do. April is Child Abuse Prevention Month. This is the first year we are hosting a blue run on April 14th in front of Gonzales City Hall. The run starts at 8 o'clock. I've got information if you are interested in coming out just to show your support, being a part of that, but it's really there when we're doing it to make sure that the community knows we are here to fight child abuse. With the 82 kids we served last year, we hate to say that we'd like to serve more because we don't want it to continue happening, but we want to serve all the children that we possibly can who are subject to this kind of abuse. So, thank you.
Next, we have proclamation to proclaim April 2012 as Bike Month in Ascension Parish. Whereas for more than a century, the bicycle has been an important part of the lives of most Americans. And whereas millions of Americans will engage in bicycling because it is a viable and environmentally sound form of transportation. an excellent form of fitness and provides quality family recreation. Whereas the education of cyclists and motorists as to the proper and safe operation of bicycles is important to ensure the safety and comfort of all users. And whereas bicyclists of all ages throughout Ascension Parish in the state will be promoting greater public awareness of bicycle operation and safety education in an effort to reduce accidents, injuries, and fatalities for all during the month of April 2012. Now, therefore, it be proclaimed, I, Tommy Martinez, President of the Parish of Ascension, State of Louisiana, by the virtue of the authority vested in me, do hereunto proclaim April 2012 Bike Month in Ascension Parish and encourage motorists and bicyclists to learn and respect the rules of the road and follow the important message of the Capital Region Bicycle and Pedestrian Safety Campaign. Don't be a road hog.
Thank you. Appreciate it. Of course. Thank you, Tommy, and parish council members, public. I want to say that the safety education campaign is over with. We had funding for exactly 1 year, but it had dramatic results. The number of crashes involving bicyclists in the 5-parish region has been down more than 30%, compared with the Orleans Parish. Their number of crashes involving bicyclists and pedestrians went up 40%. So it makes a difference. I noticed downstairs as I came in, there's still one of the Don't Be a Road Hog posters involving Michael Bitten, and the message there was, give bicyclists 3 feet. Of course, the other half of that is, bicyclists need to give motorists 3 feet. And one of the things that I do as a League of American Bicyclists certified instructor is I make sure that the bicyclists know what the rules of the road are too and follow those rules of the road. I know most people talk about, well, they're using up the whole road. Well, no, we're not supposed to use up the whole road. That's not the right thing. We stop at stop signs, we stop at red lights, and we respect all road users, and all bicyclists are asking for is the same thing. Maybe next year we can have a parish president's bicycle event. Baton Rouge has been having that for the last 5 years, and I promised Iberville, West Baton Rouge is having their first this year. Iberville, I promised them that we would have one, and I'd sure like to be able to say that we can do the same thing in Ascension Parish. We know there's a big population of people and a pent-up demand, and there is right now the trail on the east bank of the levee is being expanded southward from Baton Rouge, northward from St. John Parish, and into St. James Parish, where they have things under construction. I'd like to see the same thing done in Ascension Parish. Thank you for your time and your continued support in this effort.
Thank you, and I'll certainly be more than willing to participate if Mitch Uso will ride the bicycle also. So,
Okie dokie. Thank you.
anyway. Should have another one here. But anyway, it's basically to proclaim April as Fair Housing Month in Ascension Parish. And that's basically what it is. I don't have a copy of it up here, but I'm just urging you all to do that. It's part of a program that we have to participate in.
Okay. Thank you, sir. Item number 6 is the parish president's report. Or did you want to go back and finish the, that's fine.
Suddenly found the proclamation. But anyway, to proclaim April 2012 Fair Housing Month in Ascension Parish, whereas the 44th anniversary of the National Fair Housing Law, Title 8 of the Civil Rights Act of 1968, during the month of April is an occasion for all Americans, individually and collectively, to rededicate themselves to the principle of freedom from housing discrimination whenever it exists. Whereas this law guarantees for each citizen the critical personal element of freely choosing a home, and whereas a fair housing law has been passed by the state of Louisiana, and implementation of the law requires the positive comment commitment, involvement, and support of each of our citizens. And whereas the department and agencies of the state of Louisiana are to provide leadership in the effort to make fair housing not just an idea, but an ideal for all our citizens. And whereas barriers that diminish the rights and limits the options of any citizen to freely choose a home will ultimately diminish the rights and limit the options of all. Now therefore be it proclaimed, I, Tommy Martin, as President of the Parish of Ascension, State of Louisiana, by the virtue of the authority vested in me, do hereunto proclaim April 2012 as Fair Housing Month in Ascension Parish. Thank you.
Thank you, sir. Item number 6 is the parish president's report. Did you have anything? Okay. We'll move on to item number 7. The chair would entertain a motion to move the consent agenda.
So moved, Mr. Chairman.
Motion by Councilwoman Cazzo. Second. Second by Councilman Benny Johnson. Any discussion? Any objection? Motion passes. Item number 8, change order number 1, the Donaldsonville Park Pavilion for Hartman Engineering, contract time extension only. Chair would entertain a motion to approve the contract time. I'm sorry, who was that? Councilman Joseph, a motion to approve. Second by Councilman Dempsey Lambert. Any discussion? Any objection? Motion passes. Item number 9 is a resolution urging Senator Amity to enact a Senate bill and amending Part 11 of Title 19 of the Louisiana Revised Statutes of 1950, expropriation by a declaration of taking by the Parish of Ascension. I will ask our legal counsel, Neil Parrington, to read the bill as well as the digest of that bill and the resolution.
The bill reads, to enact Part 11 of Title 19 of Louisiana Revised Statute of 1950 to be comprised of RS 19:361 through 368 relative to expropriation, to authorize the governing authority of Ascension Parish to expropriate by declaration of taking, to provide certain terms, conditions, procedures, definitions, requirements, and effects, to prohibit expropriation for certain purposes, and to provide for related matters. Notice of intention to introduce the act has been published, be it enacted by the Legislature of Louisiana, Section 1, Title 11, Part 11 of Title 19 of Louisiana Revised Statutes of 1950, comprised of RS 1936, 361 through 368, is hereby enacted to read as follows. Part 9, expropriation by declaration of taking by the Parish of Ascension. The heading is Ascension Parish Government Authority to expropriate acquisition property prior to judgment. Definitions. It says when the Ascension Parish Governing Authority cannot amicably acquire property needed for major infrastructure, road, sewerage, or drainage project, it may acquire same by expropriation and may acquire the property prior to the judgment of the trial court fixing the amount of compensation due to the owner of the property. The expropriation of any property pursuant to the provisions of this part must first be approved by 2/3 of the elected membership of the Parish Council of Ascension Parish Government by the adoption of an ordinance declaring that the taking is necessary for this purposes of this part. B, at least 15 days prior to filing the petition for expropriation, the parish administration must notify the owners or owners by certified mail return receipt requested of its intention to expropriate the property pursuant to this part. The letter of notification must also inform the owner that if within 15 days after being served with this notice of suit, he does not object to the taking on the ground that it is not for public purposes, he will waive all defenses to the taking except the claims for compensation for damages. A copy of this part must be enclosed with the letter of notification. C, except as otherwise provided in this part, such appropriation by the parish government shall be conducted in the manner that the Department of Transportation and Development may expropriate property for highway purposes pursuant to RS 48-441 through 460. D, as used in this part, the term property means any portion of immovable property, including servitudes, rights of way, and other rights in or to immovable property. The provisions of this part shall not apply nor authorize the expropriation of property for the purpose of bicycle facilities or paths. 362, contents of the petition and place of filing. the right of expropriation granted by this part shall be exercised in the following manner. A petition shall be filed by the plaintiff in the district court of the parish in which the property to be expropriated is situated. The petition shall contain a statement of the purpose for which the property is to be expropriated, describing the property necessary, therefore, a plan of the same, a description of the improvements thereon, if any, and the name of the owners if known. The petition shall have annexed it to the following: a certified copy of the ordinance adopted by the parish council authorizing the taking and declaring that it is necessary or useful for this purpose of this part, a certificate signed by the parish or consulting engineer declaring that, 1, he has fixed the right-of-way in a manner sufficient in his judgment to provide for the public interest, safety, and convenience, and 2, that the location and design of the proposed improvements are in accordance with the best modern practice adopted in the interest of the safety and convenience of the public. C, an itemized statement of the amount of money estimated to be full extent of owner's loss for the taking of damages, or both, as in the case may be. It shall be signed by those who made the estimate, showing the capacity in which they acted and the date in which it was made. D, a copy of the return receipt from the letter notification intention to expropriate property is required by RS 19-271. Prayer of the petition, ex parte order of taking. The petition shall conclude with a prayer that the property to be declared taken for public purposes, and that upon presentation of the petition, the court shall issue an order directing the amount of the estimate to be deposited in the registry of the court and declaring the property described in the petition has been taken for public purposes at the time of the deposit. Vesting of title. The title to the property and the property rights specified in the petition shall vest in the governing authority upon final of the court declaring the property described in the petition has been taken for the project, and or the right is just and adequate compensation shall therefore vest in persons entitled thereof. Upon vesting of title, the governing authority may enter upon and take possession of the property. Notice 365, notice to the defendant. Upon receipt of the deposit, the clerk of court shall issue a notice to each defendant in the suit notifying him that the property described in the petition has been expropriated for public purposes. This notice, together with a certified copy of the order, the petition, and the clerk's the receipt for the deposit, shall be delivered by the clerk to the proper sheriff for service on each defendant in the manner provided by the service of citation. 366, contesting the validity of the taking, waiver of defenses. Any defendant desiring to contest the validity of the taking on the ground that the property was not expropriated for a public use may file a motion to dismiss the suit within 10 days from the date of notice of which he was served on him. He shall certify thereon that a copy thereof has been served personally or by mail on either the plaintiff or his attorney of record in the suit. The motion shall be tried contradictorily in preference to the judge alone and shall be decided prior to the fixing of the case for trial on the compensation or damages due to the defendant. Failure to file the motion within the time provided or serve a copy thereof on the plaintiff constitutes a waiver of all defenses of the suit except the claims for compensation or damages. 367, defendant's answer. Requirement delay for filing. When property is expropriated pursuant to this part, any defendant may apply for a trial to determine the measure of compensation to which he is entitled if he files an answer within 1 year from the date he is notified in writing by the governing authority that it has finally accepted the construction project for which the property was expropriated. However, he may file his answer prior to the date he is notified by the governing authority. His answer set forth the amount he claims, including the value of each parcel expropriated, and the amount he claims as damages to the remainder of his property. His damage claim is reasonably itemized. His answer has certificate thereon showing that a copy thereof has been served personally or by mail on all parties to the suit who have not joined in the answer. 368, grant of additional authority. The right to take possession and title as provided in this part is in addition to any right or authority conferred by laws of the state under which expropriation proceedings may be conducted and shall not be construed as abrogating, eliminating, or modifying any such right or authority.
Can you read the digest as well, please?
Excuse me?
The digest as well. Bottom of the,
Oh, okay, the digest.
yes.
Proposed law authorizes the Ascension Parish governing authority to expropriate by a declaration of taking and provides procedures. Proposed law provides that when Ascension Parish governing authority cannot amicably acquire property needed for major infrastructure, road, sewage, or drainage project, it may acquire the same by expropriation and may acquire the property prior to judgment in the trial court fixing the amount of compensation due to the property owner. The expropriation of said property must first be approved by 2/3 of the elected membership of the Parish Council of the Ascension Parish Government by adoption of an ordinance declaring that the taking is necessary or useful. Proposed law further provides that it shall not apply to nor authorize the expropriation of property for purposes of bicycle facilities or paths. Proposed law provides procedures for notices to owners, contents and filing a petition, vesting of title, contesting the validity of the taking, and conducting generally of expropriation in the same manner the DOT expropriates property for highway purposes. Provides that property means any portion of immovable property, including servitudes, rights of way, or other rights in or to immovable property. August 1st, effective August 1st of 2012.
Thank you, O'Neill. Now the resolution, please.
To enact legislation to bill, it would be Bill number 703, expropriation by declaration of taking by the Parish of Ascension prior to judgment, whereas the Ascension Parish governing authority is seriously concerned about the acquisition of property needed for major infrastructure projects, specifically sewer, drainage, and roads, whereas the parish cannot amicably acquire property needed for a particular major project, this can delay progress and can become very costly to the parish. Now therefore be it resolved that the Ascension Parish governing authority of the Parish of Ascension and the Ascension Parish governing authority hereby urges and requests that Senator Jody Amadei enact Senate Bill 703, amending Part 11 of Title 19 of the Louisiana Revised Statute of 1950, comprised of 19 RS 361 through 368, expropriation by declaration of taking by the Parish of Ascension. Certificate, I hereby certify that the foregoing resolution was adopted by the Ascension Parish Council in the regular session duly convened on the blank day of blank 2012, and the resolution has not been rescinded or repealed.
Thank you, sir. We will start with some, I have some,
Mr. Chairman, I have a question.
sure, Councilman Shixton.
And just to help us understand, what is the difference between what we have now and what they're proposing?
The only difference is the procedure.
Okay, what specifically?
Well, in a general expropriation case, the parish, if they decide to expropriate, by majority of the council could vote to expropriate a piece of property. You would then file the lawsuit, and you would begin litigation. While that goes on, the project is shut down, because if you don't have the property and you need it to proceed, you can't. What this does, it allows you to file the lawsuit. You deposit what you say is the fair market value of that property into the registry of the court, and then you, by that, take title, and you can continue with your project.
O'Neill, if I could correct you for a second, you said what you say. It's actually the DOT, you follow their guidebook, which calls for multiple appraisals, correct?
Right.
Yeah.
Right.
So it's not what the parish government
I'm
says.
just generally, and then what would happen then is the property would vest with the parish. Although someone can contest, then file an answer within 10 days saying it's not for a public purpose, and you get a hearing on that immediately.
Okay.
If the court determines it is for a public purpose, then you go forward. If not, then if it's not for a public purpose, you can't go forward at all.
Okay, but if it is a public purpose, they
You
can
go forward. The person whose
Does,
property you're taking is able to take the money out of the registry of the court. They get their money then.
Okay.
But they can reserve their right to seek further damages up till 1 year from the completion of the project.
So we still allow people, if they disagree with the judgment that we gave them, they still allowed to go before a judge and retain what they believe is a fair amount
Absolutely.
Throughout the process, but the project goes forward.
The project continues. What essentially happens is, by law, you're supposed to pay just compensation for property. You wind up paying just compensation and not hostage.
Okay.
Because if somebody stops your property, sometimes you pay hostage damages.
So the judge decides what's...
Right. At court, everybody has the same no due process, rights are violated, and the only thing that happens is the parish moves forward with the project, and they get compensated at the end of the project, or any time up to 1 year within completion of the project. They can file a suit to seek what damages they claim they suffered.
Okay, I mean, ultimately, what I'm asking, I guess, is does the homeowner, are they allowed to get the same amount of money that they were going to get through any other, the way we were doing it before?
They're entitled to just compensation. If they are
Determined by a judge.
successful in their suit for damages, they're entitled to damages, they're entitled to attorney's fees.
Okay.
Okay, before we really start the discussion on that, we can certainly ask O'Neill a bunch more questions afterwards, but I'd like to make sure we get to, the public comments here. So we'll start, I have a few of these. We will start with Charlotte Johnson.
Thank you, Council. I didn't have much time to read the House Bill 703, but thank you for reading it again. Only concern that I have, well, part of it is that maybe perhaps the overreaching of local authority. However, the 15-day that I read, when I looked at other expropriation acts, I saw 30 days in their notices, and I was concerned about our limitation. I don't know that 15 days is an opportunity for the homeowner to proceed and make the petitions that need to be looked at. I was also concerned about the appraisal report and I guess in our act it says the petition part, but I'm assuming that's more of the inquiry notice, again, that timeliness. And how that appraisal, is it determined where the landowner has an appraisal with a fair market value and the parish has two? I mean, how is that determined? None of the bill doesn't allow procedural, this is exactly what needs to be done. We don't have access to read the DOTD manual to know what our role is in this, and I don't think 15 days is enough time to really make those kind of judgments. So that's from a landowner's perspective. Thought the timeliness, the 15 days and the 30 days was just a bit narrow.
Okay. Thank you, ma'am. Next, we have Matthew Didon.
Thank y'all very much. I think she had some good points. That was one of my concerns, the timeline. And mostly, I got trouble with wording in here. And on one section where it says the parish government or the engineering firm notify you that the property's been done right, I think the word should have been said and, you know, both of them at least. But, and the other thing is, in here, you can only take the property if it's 2/3 of the vote of the council. Well, I think the resolution shouldn't pass. This resolution shouldn't pass unless you can get 2/3 of the council. I'd like to see all of y'all support it. That means y'all, it's something good for us. But if not, I'd like to see at least 2/3 of y'all, you know, the council support it before. And I talked to the author of the bill, and he told me, well, I voiced my concerns about some of the wording, and he said when it gets to committee, it could be changed or will be changed, could be changed, however you want to put it. So the other point is, if you vote tonight of supporting this, when it comes out of committee, it might not be what you voted on tonight. So I was just wondering if y'all was, you know, y'all was gonna leave y'all's options open, because after it comes out of committee, you might not like it. And I would like to see that done also. Thank you.
Okay, thank you, sir. Next up, we have Mr. Charlie Stevens.
I'm not against it. At this point, I'm not against it. But I have some concerns. One of my concerns is, I would like to know how much time did the council have to study this issue? Did they get it early enough whereby they could read it, digest it, concentrate on how it's going to affect the people in this parish? Secondly, I want to know why we didn't have a public hearing. Now, I'm going to ask this question. Do you think it is discrediting to the taxpayers in this parish? Do you think it is distasteful to taxpayers in this parish when you're doing something that's going to impact every property owner? You're talking about a quick taking his property and yet you have not given him the opportunity to sit, to discuss this thing, to understand this thing. The next thing I'm concerned about the language. Will there be slippery language? I'm talking about language that say this is what we're doing today, but when you interpret it 3 years from today, you can have some additive, you can do some other thing with it. I still believe that we can develop a working relationship between this government and the people of this parish, where we can continue to improve our parish and do what is best for our country. I'm encouraging you because there's a lot of elements of uncertainty out there. For an example, you got people believing that it's not the parish, it is the state. They don't understand the operation between the local government and the state government. They don't understand that there are reserved powers, there are implied powers. They don't understand that reserved powers of the state are those powers that are enjoyed by the state and denied to the parish. They don't understand the parish have reserved powers that they can enjoy, but these powers are denied to the state government. And we have implied power. So they're confused. They're saying, look what the state is doing to us. Well, I'm clearing it up. I'm telling them this council can prepare the bathtub water because this baby belongs to the council. We know that nothing of this nature can leave this parish and go to the state without the approval of this council. I'm asking this council, if you want to exemplify honestly to the people in this parish,
Please wrap it up,
consider this,
sir.
take this under consideration, and I'm saying we need to stop it until we have a public hearing.
Thank you, sir. Next, we have Mr. Al Robert.
This resolution urges Senator Amadei to enact Senate Bill 703, giving this council increased authority to take private property quickly. Although it is disturbing that our senator is sponsoring this legislation, this council is ultimately responsible. Major infrastructure, road, sewage, and drainage are listed. Infrastructure is defined as basic physical and organizational structures needed for the operation of a society or enterprise, or the services and facilities necessary for an economy to function. Hard infrastructure includes transportation, energy, water management, communications, solid waste, earth monitoring, and measurement. Soft infrastructure includes government, economic, cultural, sports, and recreational uses. This bill does not limit the purpose for a quick take by the government. In fact, it empowers them to take private property to do just about anything they want to. The language is broad and can be interpreted by any attorney to mean just about anything. Rationalization. We can rationalize anything you want to. You can justify anything you want to by rationalizing. The parish government does not need the power for quick taking. The state has it. They use it in major roadways. I see no reason why the parish should have this. I've had very bad experiences when property was given for local government. It wasn't taken, it was given. This is through a personal experience. What will it cost an individual if the parish decides to take your property? It sounded real simple the way he read the Senate bill. Do they have the wherewithal to go out and hire a competent attorney to represent themselves before the parish? Do they have the power to go out and get an appraisal done? You have to have a good appraisal. You have to have a good attorney to get what your property is worth that they're taking from you. I have personally given more property than I have been paid for. It should always be the property owner's choice not to have your property taken. This is one of the last given rights of American citizens to own property. We do not need local government taking it from an individual for whatever reason, I know this says for major roadways, but it should be, if you need to take it, go through the process we have in place now. Do it with a 2/3 vote of the council. The state has the power, the parish does not need the power. Thank you very much.
Thank you, sir. Next, Ms. Catherine Couple.
Good evening. There's never been a public discussion on this item until tonight. Is this your definition of transparency? Not a single member of this council or the parish president campaigned last year on quick-taking private property as a solution for our infrastructure problems. What hypocrisy. Senate Bill 703, sponsored by Senator Amedee, amended a 1950 law, appeared on the internet only this morning. The intent to file a bill to quick-take expropriate was first noticed in the official paper of record on February 23rd. Is this your definition of efficiency? Or is it an attempt to cut the public and some council members out of the process? The parish president and the council chairman requested this bill to quick-take private property. Many of the council members were not even consulted. Is this your definition of cooperation? This is not the first time our parish president has attempted to make such a power grab. Citizens, don't be fooled. Politics, not projects, drive these decisions. Quick-take will not solve our transportation problems. Better planning will. This council already has the authority to expropriate under state law. This bill will just make it easier and quicker for the parish to abuse and bully the public when taking private property. If this bill becomes law, 8 members of this council can decide any private property they deem, quote, necessary and useful, these are right from the bill, can be taken with a single judge making the final decision. Lower income residents on parish roads who become victims of quick take will be discriminated against because they don't have the means to pay an attorney and sue the parish. You may not live on a parish road now, but the parish is negotiating with the DOTD to take in 119 miles of state road into the parish system. Where are these roads? Some of our councilmen live on these parish roads: Donaldsonville Drive, Van Broussard Road, Seabro Road, Cluot Road, William Ficklin Road. I wonder if they themselves or their neighbors would like their property taken for something, quote, necessary or useful. Who will this new quick take power affect? Every property owner in the parish, no matter where your property is located. What projects are being considered for this new power, and where are they? You have provided zero information. Do you think you are kings and princes to lord over us? Any council member who votes in favor of this resolution shows his or her arrogance and inability to be a public servant. This bill is an act of aggression on the people. Only 3 months ago, you were inaugurated in this very room, and you promised to uphold the Constitution. Each of you were exhorted to listen to the people and to build trust. The very presence of this resolution on your agenda tonight and the creation of this bill have demonstrated to the people that you cannot be trusted. Thank you.
Thank you, ma'am. Next, we have Paul Couple.
This resolution raises only one question tonight, and it is this: how will Senate Bill 703 change the way the parish takes private property? Currently, if the parish wants someone's private property and the owner refuses to sell, the parish must sue the property owner and get a judgment before it begins any projects. Under this bill, if the parish wants someone's private property, the parish simply sends the property owner a notice saying, "Hello, we're taking your property." Then the countdown begins. After 15 days, a judge can take the title to property from the owner and give it to the parish. Then the property owner has 10 days to sue the parish, or the owner permanently loses his or her property and the parish can begin bulldozing. Once this happens, the owner must accept whatever payment the judge decides is proper. So unless the property owner has money to hire a lawyer, the property owner loses his property rights after 25 days, and the parish personnel could enter and move equipment onto the property. Now, why would parish administration want to do this to property owners? Well, if you read the actual bill, and as it turns out, the resolution SB 703, it actually tells us. The bill begins by saying, quote, when the Ascension Parish governing authority cannot amicably acquire property, end quote, and then it states everything I just explained. In other words, this bill implies that the parish government has a terrible relationship with Ascension property owners, because if you had a good relationship with people who own land, they would gladly give whatever land was needed. This whole process, the resolution, the bill, it is bullying, it is thug tactics, and it is wrong. Thank you.
Thank you, sir. Next, we have Joshua Williams.
Good evening. I appreciate the opportunity to speak to you this evening regarding this resolution to urge Senator Amedee to advance what's now become Senate Bill 703 in the Louisiana State Senate. First, I'd like to be clear, I do not believe that the council or the parish president have malicious intent with the urging of the passage of Senate Bill 703. I believe that the parish government is acting in what it believes are the best interests of the public in attempting to address the infrastructure problems that we all agree must be addressed. I'm not disputing the fact that the parish will be required to acquire land in order to address these infrastructure needs, but I am disputing the idea that the parish government needs enhanced expropriation authority to accomplish this. Present expropriation statutes allow for due process in district court and give property owners just options and time to dispute expropriation of their property. Senate Bill 703 makes it possible for this council to take some of those options and time away from private property owners and remove some key decisions about what is necessary for public use from the court, where it belongs, and places some of that authority to make those decisions with this council. I understand that the passage of Senate Bill 703 will make expropriation of Ascension Parish more expedient and allow infrastructure needs to be addressed more quickly. And I think we can all agree that expedient appropriation is the intent of this bill. In fact, President Martinez was quoted in the Advocate this morning saying, "This just gives us another expropriation tool where we don't delay the project." However, I do not believe that expediency is justification for infringing on the due process granted property owners by the current expropriation laws. Any encroachment, however slight, on private property should be treated carefully and taken very seriously by the public and the property owner. And I'd like to remind you that in the case of future expropriation of property, you do represent both the public and the property owner. So tonight, I call not on your sense of legality. There's no disputing that Senate Bill 703 is legal and it's been done before in other parishes. I'm not questioning your public service ability in addressing these infrastructure needs. I'm calling on your personal sense of justice to either, one, defeat this resolution tonight and address expropriation as it may arise with the laws currently in place, or at the very least, delay a vote on this resolution until your next regular meeting and allow yourself more time for careful deliberation and interaction with your constituents. I'd like to leave you with a quote from John Adams in the 1787 Defense of the American Constitutions. "The moment the idea is admitted into society that property is not as sacred as the laws of God, that there is not a force of law and public justice to protect it, anarchy and tyranny commence. If thou shalt not covet and thou shalt not steal were not commandments of heaven, they must be made inviolable precepts in every society." Thank you again for the opportunity to address you.
Okay, thank you. O'Neill, if you would come to the mic, please. I'm sure folks will have some questions. I wanted to clarify some things, too. O'Neill, I heard it said that this was a new process. I wanted to clarify what you were saying earlier. This is essentially the same process, that people have the same rights to appeal it, take it through the court proceedings, et cetera. It's just simply allowing the project to continue. Is that correct?
It allows the taking to occur and the litigation for damages, which is just compensation, to occur.
What about the set aside for the agreed upon, the money that the appraisers have come up with, that value? I understand that they can use that money to, actually, they can take that money, then they can actually use that money to fight it in court.
Actually, I've litigated from both sides.
Okay.
Okay. The governmental authority, or whoever is doing the expropriation, has to deposit the money in the registry of the court. And the property owner can take the money and do whatever they want. The cases that I've handled have all been on contingency fees, because there's a 20%, the state statute provides for 20% attorney's fees on the difference. So most of them are handled on contingency fees. I've represented pipelines, I've represented property owners. So you will get an attorney because people are willing to take it, because you're going to get paid in the end. If you are correct, you'll be paid in the end. You can use the deposit to pay for expert witness fees, which are also compensable at the end.
Okay. And then there was a question about appraisals, and according to what this bill references is following the procedure set forth in RS 48, 441, and 460, basically the state's DOTD
Right.
quick take process that they have. And I understand that that requires a minimum of 2 appraisals.
Yes.
And then the landowner also has the right to get their own appraiser?
Yes.
Okay.
And the money, but the money, whatever it is, whatever you decide, it goes in the registry of the court. The property owner has immediate access to that money upon filing an answer, even if he denies once the decision is made that it's for public purpose, he has access to it. And then he can use that money then. He can take it at that particular time and dispute the value. He's entitled to the value of the property plus damages that he may claim.
Okay. Okay, any discussion?
Mr. Chairman.
Councilman Satterley.
Thank you, Mr. Chairman. I would like to talk about 3 or 4 different things initially, but not to go too far. Then I'd like to hear some discussion from my fellow councilmen, and then ask you, Mr. Chairman, if you would allow me then to talk a second time on some of the comments I heard from the public. First and foremost, eminent domain. I did not have a lot of time, and I agree with some of the speakers that this should have been, and I believe could have been done in a more timely manner, having, like most of you folks, gotten a completed bill at 8:07 yesterday morning. I've noticed in the past, Councilman Casso, and I appreciate her doing it, newly elected like myself, made a motion to push back a resolution we were thinking about that night about the Baton Rouge Loop to give the new guys a chance to study it. I hope we at least, as a minimum, have that tonight, if we cannot absolutely come to what I think is a better conclusion. And I'll just state it right now. I think we should turn this down. It might interest everyone to know that the Florida Department of Transportation, in a recent survey the last couple of years, asked all 50 states in the continental United States very serious questions about this topic, which is better known as eminent domain. The Florida Department of Transportation requested actually in a survey that these states tell of their experiences with eminent domain on transportation, sewer, road, all infrastructure problems, and you can see that's all in Mr. Harmony's bill, about condemnation, appropriation, expropriation, quick take expropriation, vesting of the title that's in the bill, et cetera, et cetera. And then the second question they asked these 50 states, would you please give me a name and phone number? Some of these folks, by the way, I called. You can contact to ask further questions about the process. I'm just going to give you, I can't give 50 states, some information about Mississippi and then some information about this bill being proposed in our state that we're thinking tonight about sanctioning. In the state of Mississippi, they passed a law in 1997, filed in the eminent domain quick take proceeding manner. Okay? It also had a deposit with the court that we've heard Mr. Parrington speak about tonight, and the amount equal to what is called in their law FMVO, fair market value for your property. In their law that they passed in quick take, the owner was also served with some sort of a process, and I'm going to address that specifically in a minute. I ask everybody to really pay attention to what I have to say about something called ex parte. Spoke to you about this once before. I'll speak about it again tonight. The court would enter then in order to grant the right of entry after a short period of time if after process there was no notice or no action taken. In their law, it was 30 days. I've heard some concern about the time, and we can obviously talk about that as well. For the MDOT, which is the Mississippi Department of Transportation, to come in and seize the property, it all sounded fine and grand until a citizen took them to court and challenged it, wherein the state Supreme Court, state of Mississippi, declared it to be, and Mr. Williams, I believe it was, I don't mean to disagree with your opinion, sir, and I appreciate your testimony in public, saying that it's probably legal, other people are doing it. In Mississippi, it was found to be unconstitutional. The concept that the owner had to request a hearing was even argued by the state. The judge said, no, I don't accept that. When the ruling was made, the Mississippi Department of Transportation had to eventually amend dozens, as they called it, a large number of cases that were filed under this 1997 eminent domain law. We went back, they write to the Florida Department of Transportation in the query, to actually using laws that had been in our books for several decades, like ours. It's been in our books since 1950. Ladies and gentlemen, I was born in 1950. You now know my age. I'm 61 years old, and this law has been good enough for 61 years. Apparently, if we vote in a resolution tonight and this bill is passed, it's not good enough anymore. They went back, it says, decades from the quick take procedure, giving the opportunity for a hearing, and that's the mandate part I'm going to talk about in a minute. Excuse me, the ex parte part I'm going to talk about in a minute was mandated in their statute and is going to be mandated in ours if we pass this. Referencing the second question of a contact person, they didn't supply one. They simply stated, and I quote, "If requested, we will forward the decision of our Supreme Court case to you," or better yet, you can just Google it up and ask for the Lemon decision. No, I don't mean it in terms of lemon, like a car, but we need to be careful that that's not what we're going to do. Now, let's talk about ex parte. Mr. Parrington read the bill, and he mentioned that word. To be sure that everyone is comfortable with what that word means. It is from the Latin, and it's a term meaning from, by, or for one. Emphasis on the word one, a single party. An ex parte decision, quoting again from the dictionary, is one decided by a judge. We heard about that tonight. Notice, it didn't say a trial. It didn't say a jury. It didn't say anything about oral arguments. That's what a hearing is. But a judge, without requiring all the parties to the controversy, that would be the citizen who's having his or her property taken quickly, and the parish of Ascension, without requiring these parties to the controversy to be present. In other words, a judge can just do this in his chambers, at home, whatever. He can read what we say is necessary and useful to the parish. He can read the citizen's counter-argument in writing. Where's the hearing? Ladies and gentlemen, in the United States of America, the availability of ex parte orders or decrees from both federal and state courts, and trust me, I haven't slept in the last 24 hours because that's all the time I had. And I do need more time because I could probably come to you with some other things. I'm pretty confident of it because I'm on a trail of a lot of stuff. Okay? But both the federal and state courts in our country are sharply divided by a little thing called the 5th and the 14th Amendments. Again, Mr. Williams, I apologize. Which provide that a person shall not be deprived of any interest in liberty or property without due process of law. What does that mean? In legalese, in practice, this has been interpreted to mean or to require that adequate notice of the request occur for judicial relief in any controversial matter, and more importantly, an opportunity be given to be heard. We have 5 special senses, not just our eyes, but to be heard. You might say a lot more things in oral argument than just what you filed in a written brief. To be heard concerning the merits of such relief. A court order issued on the basis of an ex parte proceeding, therefore, will by necessity be temporary, most courts hold, and interim in nature. And the person or persons affected by such orders must be given an opportunity to contest the appropriateness of the order before such order can be made permanent. If you Google up Capitol Watch, this is a website run by the Farm Bureau of Louisiana. The former LSU professor for 35 years. I had a relationship with these people and I respect them greatly. And they're watching things going on in the Capitol. On June 10th, 2011, in a session update newsletter, they wrote the following. We're in the waning hours of the 2011 legislative session, and it's like a monster truck pull. The weight is getting closer to the cab with every foot. Yesterday, we helped Senate Bill 42 that repealed, wasn't putting it in, they were repealing it already, quick take expropriation power of the town of Bastrop in regard to utilities. And what a nightmare, I looked into it. So here we already have a precedent in a state, not just Mississippi, saying we made a mistake and had to go back in dozens of cases and fix things. In Bastrop, they have had it, and now they're going back the other way. In fact, on Monday, we urge you to help kill another expropriation bill, Senate Bill 85. This bill also allows quick take of utilities in the parish of St. Mary. If this bill passes, the process would be ex parte. There it is again. This means, quote, no jury, no evidence, and no trial. The property in question could be taken with a judge, as Mr. Parrington said, granting the quick take, quote unquote. Formed the Bureau, might interesting to know, was instrumental in passing legislation several years ago that created a fair and equitable expropriation process. Have we looked at that? I don't think so. Maybe someone is going to say in a minute we have, and I will stand corrected. I'll tell you what, St. Mary Parish has never attempted to use the current practice, according to the Farm Bureau, or the previous one they had on their books, like us since like we've had since 1950, in a 15-year period to resolve any issues, prompting them to file their bill. We need to be careful. The word infrastructure, one final educational point, it says in that bill, major infrastructure, I think it's comma, roads, and then sewer, whatever. Infrastructure is the basic physical and organizational structures needed for the operation of a society or enterprise, or the services and facilities necessary for an economy to function. It can be generally defined as a set of interconnected structural elements that provide framework in supporting an entire structure of development in the community. And just to list a few of them, it's beyond just those 4 or 5. So with the word major infrastructure in there, it could also be airports, bridges, broadbands, canals, critical infrastructure, dams, electricity, energy, hazardous waste, landfills, hospitals, levees, lighthouses, parks, port, mass transit, buses that we don't currently have, but maybe one day we have a CAT system, public housing, state schools, public spaces, rails, roads, sewage, solid waste, telecommunications, utilities. I'm going to stop. We have section 413 of the parish charter. It's entitled, for Ascension Parish, Power of Eminent Domain. We've heard already tonight that we already have a law. What does it say? It's 2 simple sentences, and as I said, we've been functioning under it for apparently 61 years. The governing authority shall have the power of eminent domain and the right to expropriate property. That's covered under state law. Without as well as within the parish for public purposes as provided by state law. Governing authority shall make fair and just compensation, and I don't have a whole lot of problem with that. Okay, but I do have a lot of problem with a judge just making a decision up front that the taking part's over with without a hearing. Because I respect the Constitution of the United States. And when I was sworn in, another member said that, and I'll come back to that if the chairman allows me a second term. I hope he does. When I was sworn in, I wasn't thinking about any of the amendments, but the 4th Amendment is important, and so is the 14th Amendment. Thank you for listening.
Councilman Turner.
Just off of Mr. Sally's comments, just make one statement. It can also be done as a jury trial and not necessarily just a bench trial. So it can have a jury and it won't be decided by just one individual.
Okay. Councilman Todd Lambert.
Thank you, Mr. Chairman. I spoke with Senator Amodei this morning, Leslie, and he apologized for not being here tonight. I think he was in session. But he also told me that if we had some issues with this bill, that we could look at it and he could make some changes before it hit the floor. So I think a couple mentioned that we should defer this for a couple weeks, which we have a timeline to do so. Because, and he was open for any changes in this bill. I just got the bill actually this morning on email. I know there was a rough draft sent to Senator Amodei roughly a month ago. I think it would have been smart to give all the councilmen a rough draft so we had something to start working with. But that's why this rush, that's my biggest problem is 2 days before the council meeting and we got to move on an issue that's going to affect the citizens of this parish big time, and I have an issue with that. So I'll let some more discussion go, but I will have a motion on the table to delay it for 2 weeks for sure until the next council meeting.
I would like to comment on that. That's different than a discussion I had with Senator Amedee today. While he did say he was open to making some changes, he stressed the importance of doing this timely because of having to schedule it, the bill and everything in the committee during a very active session. So, other discussion?
I too have concerns on the
Hold on,
timing.
Councilman Lawson, I didn't recognize you yet.
Go ahead.
Councilwoman Cazzo has had her hand up, so I wanted to go ahead and recognize her
Happy to
first.
defer if you would like.
No, that's fine, go ahead.
I was elected by the citizens of my district on a platform that absolutely discussed this issue in an indirect way. And that was that the most important thing to my constituents was roads. And I think they think sewer is important too. I am very concerned that the delay of projects cost lives. It is a public safety issue when an individual can hold up a process, a project that is important to the public. There are 108,000 people and growing in this parish. And as much as I think there are a lot of things here that we can work out, I just have to tell you that I cannot in good conscience set aside this opportunity. I have to look at this as containing judicial safeguards. I have to look at this as containing not quick. Every attorney that I have spoken to assures me that although this is unfortunately called quick take, there's absolutely nothing quick about it. It is a due process that takes a considerable amount of time, that in fact a decision can and will be made in a courtroom very much like the one, if not the one, we are sitting in. Public safety being a consideration, those safeguards, particularly that of 2/3 vote of the council to even embark on the process. I don't know how much more safe we can get than it would take 2/3 of this body to determine that this was needed. Obviously, a major holdup would have to be happening to our project for 2/3 of the people on this body to object. I understand that the parish has to comply with RS 48-441, which is all of the state's Title 48 issues, much too much for me to have read, but obviously they give us a minimum of 2 appraisals and then a 3rd appraisal. I have to tell you, I will vote for this tonight. I will not vote to delay it. My constituents are tired of waiting for this government, me included, to act. They are tired of it. I had a gentleman call me today. He said, Terry, I've been here and we're going to have sewer. I've been here and we're going to have roads for 30 years. And I promised him in that conversation today that this council had the political will to get that done and not just talked about. And unfortunate as it may be, this is what has to happen to make that happen. And I've spoken with the city's attorney. The city of Gonzales has quick take. They utilize it. They utilize it as frequently as they have to. But they have it, and it has made it possible for them to do what they need to do for their constituents. We have got to have this. We may need to adjust a few words, fix 2 or 3 things, but ultimately, gentlemen, we have to have the public safety in mind, and we have to have the political will to get it done. I had a gentleman call me today who said to me, I'm not going, you better watch it because you're not going to get voted for the next time. And you know what? Honest to God, I don't care. I am not here to get reelected in 4 years. I am here to do what this parish needs to protect its citizens, all of them, the children and that are in buses on bad roads. It is time for a change in transportation in Ascension Parish. And I am not going to be satisfied until we get it. And if we can't get it, you don't have to worry. I won't be a councilman in 4 years. I don't want to participate in a body that cannot get done what the public demands that we do. And I'm off my soapbox.
Councilman Meloso.
Yeah, Ms. Castro, I agree that we need to have the public safety in mind, but I think we also need to have individuals' rights in mind. And I very much don't take lightly any time anything comes up that will in any way infringe on any property owner or any citizen's rights. And so to say that you can't put this off any at all for a resolution and a bill that first time I saw a resolution was Monday night. The first time I saw a bill was this morning. I made calls to people, to lawyers that I know, some of my good friends that could give me a call. I haven't heard back from them yet. They haven't had time to answer. I haven't had time to do enough research to make a decision on this. And to say that it's putting the public safety not in mind by not taking the time to make sure that it's researched enough that we have the information we need to make a proper decision, I don't think is right. And on top of that, Doc mentioned the St. Mary bill, which actually would have bore the same numbers as this bill. That was written last year. It was stalled. I'd like to know what happened with that bill. It passed through the Senate, got to the House, and it was killed in committee. What's the problems they found with that bill? I haven't been able to get an answer on that yet. I mean, we need more time to research this before we just push it out and get it out there. And not just to make those little changes. It may be the whole bill. We don't know. Why was that thrown out? But I don't think making a decision tonight would be the right decision to make. I think at a minimum, we need to push this back 2 more weeks and make sure we have enough time to research it and get all the facts.
Okay. Councilman Johnson.
O'Neill, question for you, sir. Councilman Satterley mentioned Mississippi DOT law and that being tried and found upheld as non-constitutional. Has anything been done as far as the statute that we're talking about today in the state of Louisiana?
Yes, sir. In the state of Louisiana, through Department of Highways versus Olden Craft, 350 Southern 2nd, 865, our quick take statute is found constitutional.
Can you speak into the microphone, O'Neill? I'm sorry. Would you repeat
Sure.
that? Thank you.
In the state of Louisiana, through the Department of Highways versus Olden Craft, that's 350 Southern 2nd, 865. Our Supreme Court found that our quick-taking statute was constitutional. It went to, someone contested that all the way up to Louisiana, the U.S. Supreme Court, and the U.S. Supreme Court denied certiorari, meaning they didn't involve themselves in it. So that was in 1977. It was found constitutional. It's been used since then by DOTD.
Okay, so while I appreciate the diligence of folks to do their research and making sure that we are making the right moves, I think we have to look at what's happening within the state as far as that goes and what our law, how it differs. I'm not 100% sure, but obviously it must differ some way if it's being held up by the court system. Mr. President, do we have any, I know I've had conversations with you in the past. I'm not sure if anybody else has about this type of an issue. Do we have any information as far as the amount of dollars that this type of an issue has cost the parish in the past, or a list of projects that we have been delayed on for this?
I have a list of projects that I certainly can hand out to you. Most recent being West Worthy Road. In that situation, it took us about 4 years to get the right-of-ways straightened out. And basically it wasn't because the people weren't willing to sell the property. It was because people had died, they had no wills. A lot of times the problem was with heirship, with so many heirs. This way, we probably could have finished that project in a year, and it took us 4 years. Now, how much did that cost us? I don't know. We had a similar issue on Joe Severio Road, a couple of them recently on Roddy Road, several on drainage. You know, if we plan on doing major projects, I'm certainly in favor of taking out the word infrastructure and certainly identifying drainage, roads, sewer. I don't have a problem with that.
Utilities.
And then right away, you know, just right away. Certainly don't want to go take somebody's house. I mean, that's not the intent of this. I don't think there's anybody on this council that would want to just blatantly go out and take somebody's property. I mean, basically, you have expropriation rights. That's correct. But I think by saying that you don't have, under quick take, you don't have due process, I don't think that's the correct statement, because I think you have more due process. And in the instances where we've actually, it does cost us a lot more, and sometimes we're held hostage. I'm not going to name any names, but a couple of these recent projects, we ended up paying a lot more than we should have, but yet it was still a lot less than having to pay damages to a contractor of $500 a day and being held up for a year, 6 months even. I mean, we had a 3-month delay on Roddy Road. We had a 2-month delay on Roddy Road. If you want to ask Mr. Bill how many times during this drainage project we were held up and how much money that cost us. So again, it's not a question of us going out and taking people's property and just being prowling on the public. That's not what this is all about. As I said, the main component here, if you are serious about doing a sewer project and you are serious about improving highways, if you don't have this too, as part of your package, you can certainly check with other municipalities, other parishes, the state, and you will see what happens. You won't get these projects done. Now, today, what we're talking about is going on in Ascension Parish. I mean, we're not introducing anything new. Safety-wise, where you have Stringer Bridge Road by Randy's house, where the 2 children drowned. I mean, the state has expropriation rights. They're probably going to widen that highway there as one of the safety factors. Now, if they didn't have that expropriation power at that point, you know, if one landowner didn't want to do it, that's going to delay basically what you're saying, Ms. Cazzo, that project. So, again, whatever your decision is here tonight, keep in mind that I do not think in any way, shape, or form we are taking due process away from our citizens. And, you know, I don't know what the deal is in Florida. I don't know what the deal is in Mississippi. But I do know what it takes to get a project done, and it's another tool. It's giving you just the ability to get the job done.
Okay.
Mr. Chairman, I have a list of all these projects. If you would like, I'll pass them out.
If you would, please, that would be great.
I think Parish President went a little bit more than what I asked him, but I appreciate one of the things he brought up with. I know personally in my district, since I've been on the council, I've dealt with a couple of issues to where succession hasn't been done, and that's created a lot of issues, a lot of added costs to projects, of having to go back and do research to find multiple airships going back to, I had one gentleman, I think it was his great-grandparents, that the property was still in their name, and recently his mother and father had passed, so there was at least 4 generations of having to go back and research and find. And sometimes we were lucky in that particular case where I think we only had 2 heirs, but I've seen other cases. I've got a relative that's got down about 18, 19 relatives that are involved in succession part of the property because it wasn't done as the original owners had passed away and moved on to the different heirs. And I think that I also agree and do not have an issue with taking out the major infrastructure part or part of that ordinance or law, that bill that Senator Amade has before the state Senate, and putting that through. And when it comes to an issue like drainage, I think this is actually adding a lot more transparency to the process that we've been using for years around here. I have been having discussions on the way that we have been going about taking property from people as far as drainage is concerned, and I don't agree with the way we're doing it. And this right here gives them the ability to add more time or not necessarily more time, but more rights to go in and confront and get with somebody else that's going to tell us how exactly we need to deal with those folks in a more fair and reasonable manner. This is one of those things that I too will support move forward tonight. I think it's the right way to go. I don't know of anybody on this council that is in a rush to go out there and take somebody's property just so we can do it. I know I wouldn't support it. It's got to be some real just cause for doing it. But I also think, like Ms. Castle and others have stated, that we have been put up here to make some progress happen in this parish and also make sure that we are doing right by the people, and I think this helps out.
Okay.
Mr. Chairman?
Before you speak again, I would want to make sure everybody else had a chance to speak. Okay. Councilman Joseph?
Yeah. My biggest concern is the infrastructure, and I agree with the parish president, it must come out. If then the infrastructure just leaves it too vague on what we can do. And the public always, you know, we have to be honest with the public. We leave that vague in it, that we're going to put that doubt in. So, you know, one of the most important things is to remove that infrastructure word out of it. That's
Okay.
it, Mr. Chairman.
Thank you, sir. Anyone else?
Yes.
Yes, I would like
Okay. Wait, hold on. I want to make sure just everyone has a chance, and then I'll come back to you. Okay, let me call on Councilman Kluwat first.
Thank you, Mr. Moore. Basically, some of the concerns I had at looking at this over the past month or so, and looking at the issue of quick take versus basic expropriation, looking at the way I've talked to people with DOTD and what they do, and they do the same thing that we're looking at here, and it's usually a last-ditch effort, and a very large number of times it's not necessarily with a disagreement with the landowner. It's based on succession of land, someone not being able to be contacted, things like that, and that initiates that. But even with the landowners, I've talked to a couple lawyers and some folks in the legal field that have represented. I didn't talk to O'Neill, but I've talked to some other folks, and that the landowners generally come out pretty good on the when they go and try to get what they think is more fair, all right? And you know, I mean, Benny had talked about drainage. I work with drainage. 20-something years ago, I signed paper for some land I got to clean the canals out, okay? Well, they probably got other people that didn't sign, you know. They might have got paid good money for it, I don't know. I was satisfied with getting the water to where I didn't have to sandbag my house. But on this issue, the time frame, I would like to be clear on the time frame of the notification, you know. And that seems to be a complicated issue with some folks on the 15 days, and, you know, talking about prior other documents that had 30, you know. Thank you.
30 days then becomes the litigation over whether it's for public purposes.
Right.
15 days to file an answer in the
That's one of the things I wanted to clear up, you know. And the next fact that any action comes to 2/3 vote of the council. I mean, you guys have watched us vote in the past. You know, some of you have watched generations of vote. And I agree that when two-thirds of the council of a mixed group of people that represent the whole parish, then it's usually a pretty good thing. And, you know, I just want the due process for the landowners. And I can tell you right now, when talking about this, talking about projects, I've been in here for 4 years, it's going on, you know, I'm in my 5th year, is that I did see the projects. I saw projects that's with some of you other council members that's been in here longer, that were dragging on and dragging on and dragging on, and you know, being in construction, you know, I'm asking, what the heck's wrong? You know, somebody's messing around with it, you know. And you get to looking in, and you've got 5 miles of road with one landowner, okay? All right? I know someone had walked up tonight and they said, you know, if we engaged the residents of the parish and everybody's happy, then they would gladly give their land.
Well, folks, I face this in reality every day. Not everybody is happy, and not everybody's willing to give their land. Even some of the folks that really need the improvements of the infrastructure, and I'll quit using that word for sure, the improvements of the road, improvements of the drainage, improvements, the utilities coming in, to be a better thing. Trying to get sewer in, trying to get water in, good water in, sewer to where we can go back and you can swim in the bayou if that's what you want to do, like I did when I was growing up. You know, instead of it being a very large sewage ditch. And we can get things in place. This is going to take a long time. I'm not going to be here whenever everything is finally finished, okay? And some of you guys, I see people in the audience that's been involved for a long time. You know, and y'all been involved longer than I have, you know. Well, we need to set some rules in place. I'm talking to several organizations that use this, and I've actually had the opportunity to talk to one person that this quick take was done. And he said he was all against the process, but at the end of the day, he came out all right. And he was all right with the project, okay? He just hated to give up 10 feet of his yard. Keep in mind that a lot of this has to do with servitude. I don't mean the road's coming 20 feet closer to your house all the time. That means that there's servitude. One of the projects right there at Highway 935 and 431 in my district, I have someone that is losing on the north side of that intersection. I have 3 to 5 residents that are going to lose some land through servitude for widening that intersection for safety for the school, for safety for the people on the highway, okay? All right? There's a heck of a lot of engineering going into to take care of things there. And at the end of the day, part of it's going to lose the ditch, all right? So the road's not going to be all the way. I still feel for them. On the south side of that intersection, they have 2 businesses. One of them's going to encroach into the business parking lot a decent amount. The next one's going to cut a business off during construction and encroach in them where they got to move. They've got to move some equipment, okay? All right, they've got to kind of rework their place. And also, there's a possibility of them being shut down from their access for a while. They are going through this same process right now with LADOTD to put in for not only a good land value, but they're putting in, everybody's trying to work out for compensation of whatever infrastructure they need to move to make their businesses better. The folks with the yards, they're going to, several of them are going to lose some trees, things like that. So they're working with DOTD to be compensated for things like that. So the process has been working, and it's been working for a while, all right? We have, as Terry said, she was quite adamant with it, that we, aggressively, we've listened to the people, and we need to get a plan together. We need to start working on roads. We need to put sewer in place. I would definitely like to see that. And we need water to some places, public water. That's something to be looked at down the road. So this bill is probably, out of all the bills I've read, it's barely short. It's simple language. I definitely agree, because some of the people that I've talked to in my district are worried about it. I got a nice, pretty field right here. All of a sudden, the parish needs a new ballpark, so they're going to come expropriate my pasture for a ballpark. It's not going to happen. There's some clear lines in this. This is written simple. So tonight, with clarification on the infrastructure, and that we do make sure that we covered utilities, I don't have a problem backing this tonight. Thank you, sir.
Okay, thank you. Councilman Johnson?
Mr. Chairman, I'd like to go ahead and make a motion at this time that we move the resolution with the word major infrastructure
A point of order,
stricken
Mr. Chairman, I
out.
believe I asked for a little more discussion on the second.
And we're going to have a discussion, and I'm going to come back to you, but,
Well, I think a motion at this point would be inappropriate till we finish the discussion. It may change what the motion might be, sir.
well, we can continue to have discussion, and I'm going to continue to entertain
Mr.
motions. I'm not going to close the debate, sir, but
Mr.
you had
Chairman,
plenty of time,
question.
you had plenty of time to speak, so I'm going to, if somebody else wants to speak a couple of times, I might allow that.
I guess it wouldn't do any good to talk about Robert's Rules of Order.
I'm following Robert's rules, sir. You actually,
I don't believe that's the case,
Yeah.
Mr. Chairman, with all due
Yeah.
respect. I mean, the discussion is not closed, and we haven't.
I'm not going to end the debate, so I'm going to allow you to make whatever motions you want to make or speak again,
Thank
or
you,
what
Mr.
have you,
Chairman.
but there's a motion on the floor, and I've recognized Councilman Johnson. Okay. Continue?
I would like for the resolution to strike the word major infrastructure, as well as include in the resolution to have Senator Amedee remove major infrastructure where it appears in the bill from the bill.
Okay. A motion as stated by Councilman Johnson. Do I have a second? A second by Councilman Joseph. Discussion continued. Councilman Satterley.
Thank you, Mr. Chairman, and we'll start with you, and we'll go around the horn here with all the different things I heard from the councilman and our parish president, Mr. O'Neill Farrington. And first of all, I thank everyone for their concern about me doing my due diligence and what it might or might not mean. Relative to Robert's Rules of Order, though, I'm going to start with that, okay? In the past, at least in the meetings that I've sat, we've always had a motion first, which was incorrect. Tonight, I was delighted to see that we had a discussion first, but then we allowed a motion in the middle of it, and then we're going to discuss again. And I assure you, sir, Robert's Rule of Order does not contain that scenario. I want to read from the resolution again. It says, whereas when the parish cannot amicably acquire property needed for a particular major project, this can delay progress, and can become very costly to the parish. So if I sign on this, I'm saying I believe that's so. Well, I don't believe it's so. In fact, I think I can reasonably maybe convince some people that it's not so. Let's take delay progress. Both the parish president and Council Lady Terry Castle spoke to this. Are we to believe tonight that the lack of a quick take has delayed the progress on a parish-wide sewer system? When I can read the push cards of the parish president and multiple term councilmen sitting here with me tonight that ran on a platform as much as 15 years ago, in 1996, a parish-wide sewer system. I don't think so, and I say this with all due respect. The parish president said it's not introducing anything new. If that's correct, why do we need a new replacement? Bill, why don't we just keep the one we've had for, as I mentioned earlier, since I was born in 1950, 61 years ago. Certainly something must be different about it. And since it was requested, according to the newspaper article, I see Mr. Mitchell sitting over there, by our parish president and our chairman, they must have thought we needed something new. Mr. Kluot, again, with all disrespect, you talked about
With
the
all
word
disrespect?
With all due respect, sir.
Okay.
Come on, Randy.
You said this.
He said disrespect,
this.
so that's why I cried.
All
I
due
figured you was
respect.
wrong.
Did I say that?
Yes, you
Yes, you
did.
did.
That's truly a Freudian slip there, huh? What's in the word? Infrastructure.
That's what we're discussing,
Laundry
what's in
list.
a word.
Well, the laundry list I led would include roads, sewer, drainage, etc. In fact, I was sort of troubled when I read it. Why don't you just say major infrastructure and skip the other three words? Because reality is that lengthy laundry list, I don't want to read it again, just about everything in it was either directly or indirectly related to roads, drainage, and sewer. Councilman Turner, you started off and said that you wanted to let me know that we can have a trial by jury. That may be so, but the bill I read, and let me read from it, under page 4 of 5 on line 13, and I'll skip down a sentence or two. Well, let's just start with line 17. This motion shall be tried contradictorily with preference to the judge alone. In my opinion, that's why it says earlier in the bill that it's ex parte, and I won't read the definition of that again. That means without a hearing. So while that could happen, is it happening here? Mr. Parrington, you said that, and I apologize, sir, I cannot quote who versed who, okay? and I don't have the ability, hopefully the parish one day is going to get me a smartphone device or something, I can look at things right here on the spot as well, like the case that I saw you look up. But whatever the case was, sir, I would ask you, in that case you cited, is that an ex parte quick take that was found to be constitutional in our state? In other words, was there an actual hearing?
I think you need to understand the difference between ex parte and a contradictory hearing. Ex parte is the initial file. The defendant then has a chance to file an answer and get a hearing.
So why can't we say that in the bill? Why can't we say there will be a trial hearing?
Because that's the state, that's how it tracks the state quick take. The ex parte order is taken. If a person opposes, they can come in and file an opposition, and they're entitled to a hearing.
But would you object, sir, to such language in the bill that would
Yes, because I think
specifically
it
name
doesn't
it out?
comply with the law. I want to follow the law that's been accepted as contradictory, as not as constitutional.
Well, this is a whole new law.
No.
There's no strike-through. It's all underlined and bolded as if it's a brand-new law. That's why it's got new sections and everything.
It's based on state law for expropriations of quick taking. That's what it's based on. That's exactly what it's based on, the state's rules and regulations for quick taking. So to make changes on it may cause a problem. To follow something that is in place that works.
I just don't see how it could cause a problem to specifically state that you could be given a trial, because I've heard the people are concerned about it. They're not lawyers, they don't understand this, a trial by jury. So that we don't have the problem that I read to you earlier where the Farm Bureau was advising the other parish there was no trial, there was no jury, there was no nothing, and the judge just took your property.
The judge signs the order of quick take. And then you have a right to file an answer and have a contradictory hearing. And that's why it's done that way, because the order vests, and then you have a right to dispute it. That's what's worked in this state forever and ever. To change it is not going to work.
So you would object to the word contradictory, the insertion of the word hearing behind contradictory, is that correct?
It's just with the statute. We're tracking the state statute. I'd object to any changes in that because you're going to wind up with a problem. And you're going to wind up with a statute that doesn't work. And if that's what you want, you make changes. If you don't, you follow one that does work. This is one that's been found constitutional by our Supreme Court, which was part of our Constitution, and they give you that right in the Constitution from 1974 or 1975, whatever it is, that as long as you put the money up front, you can do the taking. It's constitutional. It's in our Constitution. Mississippi or Florida, they can pass whatever rules and regulations they want. Farm Bureau can lobby what they want. Our courts who make these decisions, and that's why I'm recommending that we follow what works.
Okay, I don't want to go a third round, but I'm just going to say this, okay? And I'm not going to say with all disrespect. With all respect, sir, I'm not a lawyer, but I know not to argue with a lawyer. And I'm not trying to be a lawyer, and I wish I heard a little remark here tonight that was a little condescending from one of my fellow councilmen that, I'm glad the guy takes a look at, I have the floor, I believe, Mr. Chairman, at things and does his due diligence, but we should just let the lawyers be lawyers, okay? I think that the task is higher than that. It is to examine things. And once again, it goes to the original complaint that I had, okay? And the major one, and the same thing that I talked to the author of the bill about. How can any of us do any kind of reasonable examination of this, loyally or not, talking to lawyers, which I have many, by the way, including the author, in less than a 24-hour period of time? It's just a serious problem for me. Because I have to right now accept that everything you're telling me is right. And it may very well be, sir, and actually I pray that it is. And I have no reason to believe that you would in any way be trying to deceive me or anyone else in your comments, okay? But it's hard to sit here and trust an entire system which is, in my opinion, whether or not, and frankly, even whether it's a trial by jury or not, I mean, you're coming in here and not you specifically, it's figuratively, trampling upon the constitutional rights of citizens as it relates to the 4th and the 14th Amendment.
We're not. In our Constitution, you have that right. The U.S. Constitution has sanctioned that right.
Why can't we just well, I said I wouldn't go again, so.
I would like to call a question on the motion.
Okay, I have a question on the motion by Councilman Dempsey Lambert. This requires a 2/3 vote. We will not be voting on the motion itself. I want to be clear. This is just voting on Councilman Dempsey Lambert's motion to close the debate, and then we would vote on the motion. So with that, I will ask for a roll call by Cinnamon on, and a yes vote will be to support ending the debate. And
Councilman Kluwat.
Yes.
Councilman Joseph. Yes. Councilman Shake Snyder.
Yes.
Councilman Turner.
Yes.
Councilman Dempsey Lambert.
Yes.
Councilman Satterlee.
Yes.
Councilman Cazo.
Yes.
Councilman Todd Lambert.
Yes.
Councilman Melanson.
Yes.
Councilman Johnson.
Yes.
Okay, we will end debate, and we will now call for a vote on Councilman Johnson's motion, which was seconded by Councilman Joseph. If you would take a roll call, please, Cinnamon.
Councilman Kluwat.
Yes.
Councilman Joseph.
Yes.
Councilman Shake Snyder.
Yes.
Councilman Turner.
Yes.
Councilman Dempsey Lambert.
Yes.
Councilman Satterlee.
No.
Councilman Cazo.
Yes.
Councilman Todd Lambert.
No.
Councilman Melanson.
No.
Councilman Johnson.
Yes.
Cinnamon, I would like to be on the record as supporting this. So please count my vote as a yes. That motion is passed. Thank you. In closing, I want to thank Senator Amedee and the rest of the Ascension legislative delegation who are in unanimous support of this. We will move to item number 10, resolution in support of transformation of property described in Exhibit A into a parish park. Mr. Parrington.
This is a resolution, we acquired property for a health unit in Sorrento. After that occurred, the cancer screening center was developed in Sorrento that does the same thing that the health unit would have done, so the health unit was never built. The recreation department would like to use that property for recreation, for a park, for health and recreation as a park. The only other alternative we have is to sell it as surplus property.
Mr. Chairman.
Councilman Shake Snyder.
Yes, been working with the Recreation Department for a long period of time to get this through the change because the land had sat idle for a long time, and they proposed a very good little walking park and pavilion for it, for the residences of the area around Sorrento. And it's a good thing in that area, and it's something that we would like to move forward on, the people of that area. It's something that's not going to cost us any money, and we can have something very nice for them. So I'd like to offer that in the form of a motion to move forward with this.
Okay, motion by Councilman Shake Snyder to move forward in supporting this. Second by Councilman Benny Johnson. Any discussion?
One discussion.
Councilman Todd Lambert.
Mr. O'Neill, no legalities because it's in the town of Sorrento, right? And we put in a parish park? Okay.
No, it's there. I mean, we own the property. It's
Okay.
already ours. And the reason we're doing it as a resolution is the parish president would have to sign on behalf of both parties. So I thought we need to do a resolution so that everybody knows what's going on.
Okay.
Councilman Joseph?
And no objection to it, I just question, is the urgency and why, it didn't go to recreation? Committee?
Recreation asked us to do this.
Recreation committee.
Oh,
It just, it's that due process. I just want to know. I know. It's just that, once again, just keep ourselves in check on that process. That's all. That's my comment.
Okay. President Martinez.
The only thing is, we haven't had a recreation in a long time, and I know that the chairman is about to call one.
Yeah, April 10th. Yeah, April 10th.
April 10th, I mean, I don't have, can't you have an objection?
Oh, no, not whatsoever. We've been working on it for probably about 6 years, so
I just want,
another month not to make any difference. We just want to try to move forward with this event.
We can add it to the agenda.
Okay.
Could we make the motion pending approval by the Recreation?
I think I already have a motion and a second on the floor, so you need to do a substitute motion if you want to do that.
I'll make that substitute motion
Okay.
pending on approval to recreation.
And I second it.
Okay, a second substitute motion by Councilman Joseph and a second by Councilman Turner. Any objection? That substitute motion passes. Item number 11 is a follow-up from last month. It's a resolution in opposition to the transfer of elderly affairs to the Department of Health and Hospitals. I will ask Mr. Parrington if he would read this, please.
Whereas the Ascension Council on Aging has been providing services to senior and adult disabled population of Ascension Parish since 1972. Whereas the Ascension Council on Aging, Inc. has as their mission to assist the senior citizens of Ascension Parish with dignity and independence in the place and manner of their choice. Whereas the Louisiana Legislature created the Governor's Office of Elderly Affairs in 1972 to coordinate the services for senior citizens of the state of Louisiana. Whereas there is a proposal to be introduced in the upcoming session of the Louisiana Legislature to transfer the Governor's Office of Elderly Affairs to the Department of Health and Hospitals. Whereas in the current proposal, Parish Council of Aging funds, senior citizen funds, state home delivered, and congregate meals and transportation funds would be transferred to the Department of Health and Hospitals, and the Ascension Council on Aging, Inc. would have to contract with a private hospital or nursing home to obtain their funds to provide services to the senior population in Ascension Parish. Whereas in the current proposal, there isn't any guarantee that the contracting hospital or nursing home will be obligated to provide the Parish Council on Aging, senior citizen funds, and state-supported medical program funds. Whereas in the current proposal, as a result of the transfer of the Governor's Office of Elderly Affairs to the Department of Health and Hospitals, all senior center supplemental funds will be eliminated. Whereas the elimination of the senior supplemental funds will result in the closure of senior centers in some parishes. Whereas the transfer of the Governor's Office of Elderly Affairs, as currently proposed, would unnecessarily dismantle a 50-year-old system that has successfully delivered services to the seniors of Ascension Parish in Louisiana. Now therefore be it resolved that the Ascension Parish Council, that the council does hereby go on record opposing the proposed transfer of the Governor's Office of Elderly Affairs and subsequent elimination of the supplemental senior center funds, and that a copy of the resolution is sent to the Governor of the state of Louisiana and all state senators and representatives who represent the Parish of Ascension. Chairman Chris Lord.
So moved.
Motion by Councilman Oliver Joseph, second by Councilman Dempsey Lambert. Any discussion? Any objection? That motion passes. I'm sorry, President Martinez, do you want to say something? I'm sorry? Okay. We will do that after the fact. Thank you, sir. Next up, we have item number 12, which is a resolution ENG-2012-02, project commitment for STPK greater than $200,000 funding for fiscal years 12 and 13, 13-14, and 14-15. A commitment of local matching funds of 20% towards proposed preservation and safety projects through the parish. We'll ask Mr. Ben Laurie if you would please come and give us an overview of what this is doing.
Okay. Good evening. We prepared a list of projects in response to the CRPC, the Capital Region Planning Commission's call for projects for inclusion in the Metropolitan Planning Organization's STP greater than 200K funding program. That's Surface Transportation Program greater than 200,000 population. It's a funding mechanism from the federal government that provides money for projects that meet certain criteria. In this case, it's for preservation of the road network and safety improvements to the road network. So 11 of the proposed projects are for preservation of the state highways in the parish. There's one turn lane improvement. It's the 42 Joseph Ario project. I'm trying to expedite that project in the state program, and that's a safety project. And then there are 3 other projects that are part of funding our internal pavement preservation program software. The state requires a 20% match be provided by the parish with the application to the MPO, and for state projects, for projects that are strictly on state roads, there's the potential that DOTD will provide the 20% match, but that's something that will be determined in the future.
Okay. Questions for Mr. Laurie or motion? Motion by Councilman Kluat, second by Councilman Dempsey Lambert. Any discussion? Any objection? That motion passes. Item number 13 is the introduction of the ordinance to revoke an 18-foot by 2-foot portion of an existing sanitary sewer servitude for Manchac Place subdivision, 7th filing, lots 342-A and 343-A. Is there any objection to introducing the motion?
Motion to introduce, Mr.
Motion
Chairman.
introduced by Councilman Todd Lambert.
Second.
Second by Councilman Randy Kluwat. Any objection? Motion is introduced. Item number 14 is an introduction of the ordinance to revoke the existing 15-foot servitude along the rear of the property, Tallow Ridge subdivision, Lot 17. I did want to mention that the Planning Commission recommended denial on this one, and as a reminder to everybody, if you wish to follow that, it will take a 2/3 vote on a motion to not introduce.
Motion to not introduce, Mr. Chairman.
Motion by Councilman Dempsey Lambert to not introduce, and a second by Councilman Todd Lambert to not introduce. Any objection or discussion on that? All right. That motion passes unanimously, and that will not be introduced. Item number 15 is to amend the Ascension Parish Code of Ordinance, Chapter 5, Animals and Fowl, to add additional fees for the impoundment of dangerous dogs or dogs that threaten, bite, or attack a human or animal. Do I have a motion to introduce?
Motion to introduce.
Motion by Councilman Schexnayder. Second by Councilman Turner. Any objection to the motion to introduce? Hearing none, motion passes and that ordinance is introduced. Item number 16 is the introduction of the ordinance to amend the ordinance establishing policies and procedures for the governing authority regarding out-of-town travel in accordance with Section 4-4B of the Ascension Parish Charter, Exhibit A. Chair would entertain a motion to introduce. Motion by Councilman Dempsey Lambert to introduce. Second by Councilman Benny Johnson. Any objection? That motion is introduced. We will move on to item number 17, which is the introduction of an ordinance directing a renewal of the levy and collection of a special ad valorem tax of 2.0 mils on all property subject to taxation within the boundaries of the Parish of Ascension, State of Louisiana.
Motion to introduce.
Motion introduced by Councilman Todd Lambert.
Second.
Second by Councilwoman Cazzo. Any objection? That motion is introduced. Next, we will head into our public hearings. And ordinances section number 18 is the acceptance of donation of a 2003 Crown Victoria for Fire District Number 1 from the City of Gonzales. Mr. Parrington.
Shift to 2003 Crown Victoria, VIN number 2FAFP71W93X220833 to Ascension Parish Government, Ascension Parish Fire District Number 1, whereas the City of Gonzales owns a 2003 Crown Victoria, VIN number 2FAFP71W93X220833, and wishes to share use in an effort to enhance and facilitate the performance of fire protection and control measures within the boundaries of the Ascension Parish Fire Protection District Number 1 in the City of Gonzales, whereas Ascension Parish Government, Ascension Fire Protection District Number 1 has a need of movable property, be it ordained that the Ascension Parish Government is the governing authority in and for the Parish of Ascension with permission and consent and request that the Ascension Parish Fire District Number 1 does hereby accept the donation and transfer of ownership of 2003 Ford Crown Victoria, VIN number 2FAFP71W93X220833, as is and without warranty of any kind, is more fully contained in the cooperative endeavor agreement attached here to and made a part hereof Exhibit A. Be it further ordained that Tommy Martinez, Parish President, is hereby authorized to execute any and all documents necessary to complete the transfer and donation on behalf of the Parish Council. The ordinance has been submitted for a vote, and therein is as follows.
Motion to open the public hearing, Mr. Chairman.
Motion to open the public hearing by Councilman Benny Johnson, a second by Councilman Randy Kluwat. Anyone wishing to speak, now would be your time to come sign in for this item.
Motion to close.
Motion to close the public hearing by Councilman Johnson.
Move the ordinance.
I need a second to close.
Second.
Second to close by Councilman Todd Lambert? Okay. And I have a motion to move the ordinance by Councilman Schexnayder. I need a second on that.
Second.
Second by Councilman Kluwat. Any discussion, any objection? That ordinance is adopted. We will move on to 21, to amend the Ascension Parish zoning map by amending the zoning of a particular parcel of land located on the west side of Highway 44, approximately 1,700 feet north of Germany Road, currently zoned as small plan unit development, SPUD, to medium intensity residential RM. Mr. Parrington.
Purpose to amend the Ascension Parish zoning map by amending the zoning of a particular parcel of land located on the west side of Highway 44, approximately 1,700 feet north of Germany Road, currently zoned as small plan unit development SPUD to medium intensity residential. Whereas this parcel of land was originally zoned medium intensity residential and was changed to small plan unit development, and whereas the time has elapsed for which to develop the property as a small plan unit development has lapsed, therefore Parish of Ascension hereby ordains that the property located on the west side of Highway 44, approximately 1,700 feet north of Germany Road, more fully described on a plat attached here to, made a part hereof as Exhibit A, be rezoned from small plan unit development to medium intensity residential, repeal all ordinances or parts of ordinances in conflict herewith, are hereby henceforth repealed, severability. If any provision of this ordinance is held to be invalid, such invalidity should not affect other provisions which herein may have given effect without invalid provisions, and to this end, the provisions of this ordinance are hereby declared to be severable. Effective, this ordinance shall be effective 15 days from adoption.
Motion, open public hearing, Mr. Chairman.
Motion to open the public hearing by Councilman Todd Lambert, second by Councilman Brian Melancon.
Motion to close.
Motion to close by Councilman Todd Lambert.
Second.
Second by Councilwoman Cazzo.
Motion to move the ordinance, Mr. Chairman.
Motion to move the ordinance by Councilman Benny Johnson. Second by Councilman Todd Lambert. Is there any discussion? Is there any objection? That ordinance is adopted. I wish to thank Officer Denby for joining us tonight. Thank you, sir. Councilman Todd Lambert.
Motion to adjourn, Mr.
Motion to adjourn.
Second.
Second by Councilman Kluwat. We are adjourned.